Court calls case people versus, is it Darius Johnson?
And yes, Your Honor, Brandon Bird on behalf of Darius Johnson for case, the case ending in 5312.
In the case ending in what? Oh, 5312. Gotcha.
Excuse me, Brian Rowley on behalf of Mr. Johnson in case ending in 1734, Judge.
Here you go. All right. And what are we doing? You're requesting an adjournment?
Yes, please, Judge, for additional plea discussions. Both, but
Probable cause conference, I will adjourn to February 5th, 2026, 9 a.m. In both matters, bond will continue.
That was January 20.
No, I gave you February 5th.
February
You want the 29th? I mean, I can give that to you.
Oh, February 5th is all right.
Well, you trying to cause me a problem, aren't you?
Sometimes my ears, you know.
All right, we're starting fast, multiple defendants, multiple cases, and the clock is already ticking. This is one of those courtrooms where everything looks casual until you realize every word said here can change someone's life.
All right, thank you. Bond will continue.
can we address one issue of bond, Judge? Real quick.
Sure.
Mr. Johnson is hoping to travel to Texas, the
Why?
Dallas area, for a family matter from January 10th through the 18th.
January 10th to the 18th in Texas.
Correct.
What part?
Dallas.
Dallas? That's where them Cowboys are.
Yeah, but they're not playing football anymore now.
I know, and I don't like
He doesn't either, Your Honor.
You don't?
Lions fan.
You're a Lions fan? Okay, that'll work. Maybe I'll let him go. Oh, you fill out a form for me.
I'm doing it.
All right. He can go to Texas. Those include your travel days, the 10th through the 18th? Yeah. All right. You can go to Texas, 10th through the 18th. Sure. All right. Thank you. I don't. I've already put him there. Off my back. Court calls case, people of the state of Michigan versus Kevin Jones.
Families and on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Kevin Jones. Mr. Jones, can you please state your full name for the record?
Kevin Jones?
I'd like to set this matter for exam, Your Honor.
For exam?
Please.
All right, your discovery is complete.
As far as I know, Your Honor.
People, other witnesses available the 20th.
We'll do our best, Joe.
Preliminary examination in person, January 20th, 2026, 9 a.m. before Judge Moore. Bond will continue. Thank you, sir.
All right.
Court calls the case, the people versus Anastasia Rakes.
Is appearing on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Anastasia Rakes. Ms. Rakes, can you please state your full name for the record?
Anastasia Rakes.
All right. First of all, Your Honor, we tried to take a plea last time and it didn't go over so well, but I did get a chance to go over the video with my client, go over the plea, and I believe she's ready to plea now. Now, I believe we have another matter that we have to discuss about the bond violation in which...
Quick legal breakdown. An adjournment is basically a pause button, not a win, not a loss. And when the judge says bond will continue, that's huge. It means the defendant stays free while this case drags forward. No cuffs today.
My client has a warrant. And whenever you want me...
She does. Let's deal with the bond violation. I may not be taking a plea today.
Gotcha. Okay. First of all, Your Honor, my client indicates to us that she wasn't drinking.
She what?
She wasn't drinking. And honestly, I don't say this about everybody, but I do believe my client at this point. First of all, the blood alcohol level was 0.04. It was 0.04. if my client would have been drinking, especially with the problem that she has, it would have been way over 0.04. It was only for that one day. If you notice that she went,
If she had been drinking, it would have been over that amount?
it would have been over that amount because my client doesn't know how to stop drinking. And
Okay.
she understands that she has a problem. That's just one thing. But if you notice that she went through Christmas, she went through New Year's, and I believe Thanksgiving, you had zeros all the way across the board. And if you remember this case, my client's the one that actually said, I don't want the breathalyzer because the breathalyzer is too easy to cheat, and put herself on this alcohol tether to show the court that she couldn't that she wouldn't drink. She indicates to me that she is a clean. She's obsessed with cleaning, and it is possible that those chemicals got to her tether. But in all honesty, Your Honor, dealing with the facts of the situation that we got in front of us, we got somebody that asked to be on a stricter, to be on something stricter, to show the courts that she wasn't drinking, to address her problem, even more, to make sure that she's not cheating the court. We got somebody that has dealt with alcoholism for a long time in life. And like I said, when she does drink, she drinks a lot. And she understands that. And she's looking for help. She's searching for help. She showed the court that she's searching for help. So when she does drink, she drinks a lot. And the fact of the matter is, that's why that 0.04 doesn't. I can understand when she told me that I'm not drinking. I wouldn't have put my kid in that situation. I'm all he has at this point. And she's been responsible. She showed her response. She showed she's been responsible.
This is one of those rare courtroom moments where humor sneaks in. Sports talk, Cowboys jokes, it sounds light, but don't get it twisted. Judges do this to read people. Comfort can turn into credibility or into a trap. What do you think, harmless banter or subtle test?
Like you told one of my clients, the most major drinking holiday days that then came with Thanksgiving, the day after Thanksgiving, New Year's Eve. She showed that it's been nothing in her system. So I do believe it was an honest mistake, and I do believe that my client can't just drink one beer, and I honestly believe that. So, Your Honor, we're just asking that you give my client a chance. She showed you that she could go without drinking. I believe that violation. When was that violation, Your Honor? November or December 13th?
December 17th
December 17th.
into the 18th.
But if you notice the alcohol level was dropping when it went into the 18th. So it went to 0.04 and it went lower. It went lower and lower each time. So it's not like she was continuing drinking.
Which cuts against the fact of thinking that it's a chemical. Because a chemical that wouldn't happen.
I'm
It
not.
would either remain or it would dissipate faster than the body would be absorbing any alcohol.
And that's why she didn't say she knew it was a chemical. She said that could be a possibility. But one thing she said, I know I wasn't drinking. And for the fact of the matter, everything surrounding this situation, I believe she wasn't drinking. Now, even if we were to take that not to be true, what she said to me, I do believe we have a lot of mitigating circumstances to allow my client to stand out of jail. But I'm standing in front of you today that's saying that I really believe my client when she said she wasn't drinking. I seen the video of when she drinks. I heard the discussion. That the witnesses had with the police that talks about when she drinks and how much she drinks that she just can't stop. So a .04, I can't see my client taking a sip of anything and stopping. I can't.
Response from the people?
I would think it up to your discretion, these sorts of things as I always do. Like .04 to me is not nothing.
Right. How long has she been on the tether?
For about 2 months, maybe 2 months.
Pardon?
Yes.
New case, new energy. And notice how quickly the tone shifts. When the court moves on, there's no emotional carryover. Each defendant gets a clean slate, but also zero patience.
I've been on it like a month, 2 months.
And as I stated earlier, Yana, she's the one that was taking the breathalyzer and came in here and asked to be on the tether instead of the breathalyzer to ensure that she doesn't go to
Here's what I'm gonna do.
hospital.
You want this adjourned, right?
The bond violation, we were going to,
Go ahead, what?
we'd like it dismissed, but if we can adjourn it, Your Honor, then yes, please. We would like it adjourned, but I do know my client is ready to proceed with the plea, but if you're not at that point, then
I'm not at that point yet. I mean, I'm not saying that I won't, but here's what I'm gonna do. I'm gonna adjourn the probable cause and the bond violation. I'm gonna adjourn it out to February 12th, 2026, 9 a.m. And I'm just gonna say it this way. What I really of right should do is I should put you in today. I'm not gonna do that. Mr. Bird has convinced me not to do it. That is something that is against my normal practice, but I'm
Thank you.
not gonna do it. Well, don't thank me yet. Because normally you might spend a week, 10 days, get you help, do whatever. But now we're gonna make a deal. I'm gonna adjourn this out to the 12th of February. We have any event whatsoever, I'm not listening to any of that. I'm not listening that it might be a chemical. I'm not listening that something went wrong. I'm not listening to anything. You're just going to go in and you're going to do 60 days. Understood?
Yes.
So we'll put it up to that date. And continue.
thank you, Your Honor.
Yes. The warrant's going to. So reinstate the previous one. Court does call the case of the people of the state of Michigan versus Ronald Fleming.
Good afternoon, Your Honor. Ashley Lottie, Fellows people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Fleming, who is not present in person today for the record.
Yes.
And the people submitted a motion, Your Honor, all that, Ms. Londy.
That's correct, Your Honor. The sum and substance of our motion the court has reviewed is basically to ask the court to have an iPad brought to the defendant's cell. He's refused on a number of occasions, both before and after being found competent, to come and participate in these proceedings. I know the court is very familiar that the people are entitled to a speedy resolution of the case, just as the defendant is. We are asking that the court have the iPad brought into his cell at his next PCC, advise him of his right to be present, and if he should continue to refuse to come up, to make the finding that he is voluntarily refusing and allow us to get this set for a preliminary examination and go ahead and continue on. I think defense counsel has a couple of other concerns. I'll let them place on the record, but essentially we just want to get the case moving, Your Honor.
Understood.
Your Honor, I would echo much of what Ms. Londy said. I obviously want an opportunity to speak with my client as well. He's been refusing to see us for months now. In terms of what I am looking.
This is the heart of the drama right here. Defense is arguing science versus suspicion. A 0.0 for reading is low, legally under the limit, but bond conditions don't care about DUI standards. The tether doesn't ask how drunk were you. It asks one thing: did alcohol enter your system at all?
For is, I imagine that the court is going to compel him to come through at least what Ms. Feltz has suggested, through an iPad, through the cell, and that's all fine and well. I just think at this point, I don't know what he looks like. I haven't talked I know what he looks like. I just don't know how he appears at this point in terms of where he's at with competency. So I think this would give us a good opportunity to at least to see him, be able to evaluate him either on the record or explain to him, the consequences of not participating in preparation for his examination. It would give me an opportunity to tell him as well that we do have a social worker in our office, and I'd like an opportunity for her to start working with him. I think that would be an excellent idea in terms of getting him prepared. Otherwise, Your Honor, I would just be asking to compel for PCC in lieu of an exam at this time. I just want, again, to get an understanding of how he appears for purposes of whether
that's what I'd be doing. I'd be adjourning this out, compelling him to appear via through the tablet, apprise him of that he needs to participate basically in the proceedings, and that if he doesn't, the proceedings will go forth without him. I will let you know that in the past when we've had this issue, and it occurred in a different way, but where we had a defendant that voluntarily or may have involuntarily decided he did not want to be present, but voluntarily, but how they did it. Then at the exam, a tablet was placed outside their cell. The exam is conducted. They're there. I try to allow counsel an opportunity to converse with their client where it's going to be necessary, but we just proceed with the exam. So that's how I'd anticipate this proceeding, given his failure to do that.
Certainly.
Thank you, Your Honor. In my review of case law, it's pretty clear that he has to be given the
No.
information, and then it should be perfused, then we can move forward without it.
That's right.
So I appreciate the court doing this.
So I'll adjourn the probable cause to the 22nd at 9 or what, it will be in the 9 o'clock block. And then we'll get the first part of this done. I would need, if you would, Ms. Feltes, I'll grant your motion. So if you'd prepare a written order to that effect, so that.
I will, or I will ask a friend for help. Yeah.
Okay.
And then, Your Honor, I would ask the court for future consideration, understanding that this is being set for a PCC first. I would ask the court for future consideration in setting this for an exam for a special date. I would be asking that it be set for some Friday in the future. And that's for purposes
You know
of
what judges are available on Friday?
this one.
I'll let you.
Judge Washington?
I will let you ask on the 22nd.
Okay, thank you.
Not sure what answer I'll get.
All right, and that's for purposes, I know Mr. Pesky wants to be involved in this. So
Mr. Noveski wants to be involved?
she wants to sit second chair.
No, that's not happening. Then I'm going to make it as. All right.
I'll give her your regard, Your Honor.
Yes. Bond will continue.
Thank you.
Thank you.